This is Health Care Bill Part number 55. And we had already covered all the exceptions. We actually, in the last video, showed you where they were talking about abortions and specifically what they said. You guys can interpret all you like. I'm getting the idea that when it comes to abortions, the government will only pay for abortions that are from rape cases or from the mother getting ready to die, because if she doesn't get the abortion, she's going to die. So that's what I got out of it. If you guys got anything else out of it, I'd love to hear what you have to say. Okay. Now, it says assured availability of varied coverage through exchanges. If you don't know where we're at, we're on page number 52. We are in section number 1303 of the healthcare law. I know it keeps saying healthcare bill. It was a bill when I started covering this. Now it's a law. All right. Now, what the thing says in here is that when you have the state exchange, and you're going to hear a lot about this, when you have the state exchange, there's going to be at least one health insurance provider that is going to provide money for abortions of all kinds, and then there's going to be one health insurance provider that is not going to pay for any abortions whatsoever. Okay. And this was designed to specifically appease the people that were pro-choice and the people that were pro-life. Okay. The way I feel about it is that I have a feeling, just a gut reaction here on this, that eventually the pro-choice abortion health insurance option will end up actually being cheaper than the pro-life insurance option, thus causing the pro-life insurance option to eventually go out of business. Now, that's just speculation. I don't know that it will actually happen or not, but that's the way I'm thinking. Anyway, so that's what this Part D is all about, is saying, well, if you're going to run a state exchange, you have to have at least two health insurance plans that people can choose one. One for the pro-choicers, one for the pro-lifers. Okay? Now, I'm not sure how they're going to pull that one off, but okay. All right? Now, we go down here to number 2. And then it starts talking about prohibition of the use of federal funds. If the qualified health plan provides coverage of services described in paragraph 1B1, this is where it's covering abortions, the issuer of the plan shall not use any amount attributable to any of the following purposes of paying for such services. Okay. The credit under Section 36B. Now you say, where in the thunder is the Section 36B of the Internal Revenue Code of 1986? Well, it took a little philandering, but I found it. What does Section 36B have to say? Well, it says refundable credit for coverage under a qualified health plan. What is this refundable credit? Okay. This is a credit. It's actually a deduction off of your federal income taxes, okay, that you normally get. It would be a federal tax deduction for the premiums that you're paying for your health insurance. But when it comes to paying for abortions, the amount that you're paying the health insurance provider to pay for these abortions, that's not a part of this tax refund. Okay. So you're not going to get credit for what you pay for abortions. And I mean, it goes on here. We're talking about it. Premium assistance amount, which says the premium assistance amount determined under this subsection with respect to any coverage month is the amount equal to or lesser of the monthly premiums for such month for one or more qualified health plans under the individual market within a state which cover the taxpayer's spouse, or any dependent as defined in Section 152 of the taxpayer, and which were enrolled in through an exchange established by the state under 1311 of the Patriot. So in other words, we're going to be covering Section 1311 soon, and that's what this is talking about. Okay, so basically what it is that whatever you pay for in abortion care, you can't deduct off your taxes at the end of the year. And that's what this is all about. Because in that case, what would happen is that the government would actually be paying for abortions, and they're saying that's not going to happen. All right? Now let's go back over here. Any cost-sharing reduction under Section 1402 of the Patient Protection and Affordable Care Act, in other words, we're going to be talking about Section 1402 and Section 1412 of the healthcare law. And when we do, what they're going to be talking about in Section 1402 is a cost-sharing reduction. And we'll get into that when we get into Section 1402 or 1412. The cost-sharing reduction cannot be used to pay for your abortion services. That's what they're saying. In the case of a plan to which subparagraph A applies, the issuer of the plan shall, out of the amounts not described in subparagraph A, segregate an amount equal to the actuarial amount. Now, then you go and said, what? Wait a minute. Actuarial? What the thunder is actuarial? Okay. Well, I found out the definition of an actuary. And an actuary is some kind of a business person. And he does this mathematics to figure out the financial impact of risks and uncertainty. Now, what do we mean by risks and uncertainty? Well, you would have an actuary who would, if you built your house like in areas that were prone to things like Hurricane Sandy, he would figure out how vulnerable your house was to something like Hurricane Sandy. And then based on what he figures out, then the insurance company would say, all right, you have to pay a certain amount of premiums per month because you live in an area that is susceptible to Hurricane Sandy. Now, your premiums can go down, okay, per se, if you invest in your home and you make sure that you do everything you possibly can to minimize the risk to your house if a Hurricane Sandy shows up. Then, of course, your insurance goes down because if you got a really solid home during something like Hurricane Sandy, there'll be very little damage, and then that means that the insurance company wouldn't have to pay you out very much if a Hurricane Sandy occurred because you would be losing your house, so on and so forth. It's just like they have actuaries that work with cars. If you have a totally safe car, your insurance on your car is going to be less, especially if you're a really good safe driver, because there's very little risk that the insurance company will ever have to pay out to you because of a car wreck. But if you've got an unsafe car and you're not a very safe driver, of course your premiums are going to go up because eventually they're going to have to pay you out some money because you got in a wreck. Hopefully you understood all that. If you did not understand all that, go ahead and leave a comment down here below and we'll just go right on through it. Alright. Actuarial value of optional service coverage. The Secretary shall estimate the basic per enrollee per month cost determined on an average actuarial basis for including coverage under a qualified health plan of the services described in paragraph 1B1. So what he's going to do is determine how much risk. You see, abortions have risk. There's no question about it. People can actually die of abortions. People can live with lifelong debilitating diseases because of an abortion. And so what they're going to do is determine how much you're going to pay in health insurance premiums to compensate for what you may have to deal with later on. So the considerations of making such an estimate, the Secretary may take into account the impact of he may take into account the impact on overall costs of the inclusion of such coverage, but may not take into account any cost reduction estimated to result from such services, including prenatal care, delivery, and postnatal care. Shall estimate costs as if such coverage were included for the entire population covered. I know my camera keeps giving me trouble. Well, not really the camera, but the tripod. May not estimate such a cost at less than $1 per enrollee per month. Okay. So this is kind of one of those things where they're calculating how much you're going to pay in premiums because you have this abortion care in your package. Provider conscious protections. No individual healthcare provider or health insurance facility may be discriminated against because of a willingness or an unwillingness, if doing so is contrary to the religious or moral beliefs of the provider or facility, to provide, pay for, provide coverage of, or refer for abortions. So, if a health insurance provider does not want to provide coverage for abortions, he can't be kept out of the state exchange. Okay. Okay, finally, application of state and federal laws regarding abortion. No preemption of state laws regarding abortion. Okay, so federal law will not supersede state law when it comes to abortion. Nothing in this act shall be construed to preempt or otherwise have any effect on state laws regarding the prohibition or requirement of coverage, funding, or procedural requirements on abortions, including including parental notification or consent for the performance of an abortion on a minor. So basically it boils down to this. If a state says, hey, in order for a minor to get an abortion, the parent has to give consent, then the federal government can't come by and say, hey, you can't do that. They can go get their dang abortion whenever they want, and they don't have to have parental consent. Well, this law says, no, the states will decide whether the parents have to give their consent before the minor can have an abortion. That's a state matter, not a federal matter. No effect on federal laws regarding abortion, and in general, nothing in this act shall be construed to have any effect on federal laws regarding conscious protection, willingness or refusal to provide abortion, and discrimination on the basis of the willingness or refusal to provide, pay for, cover, or for abortion, or to provide or participate in training to provide abortion. Abortion. No effect on federal civil rights law. Nothing in this subsection shall alter the rights and obligations of employees and employers under Title VII of the Civil Rights Act of 1964. If you want to look up Title VII of the Civil Rights Act of 1964, you are more than welcome to. Application of emergency services laws. Nothing in this act shall be construed to relieve any health care provider from providing emergency services as required by state or federal law, including Section 1860, Section 67 of the Social Security Act, so on and so forth. So this law will not change the emergency services law. Wow. So that concludes the abortion part of this healthcare law. If you have any questions, you can go ahead and leave them down here. If you have any information, you can leave that down here as well. The next thing we're going to be covering here is section 1304, which is related definitions, and definitions relating to markets, individual market, large and small group markets, etc., etc., etc. I will tell you more in a future video, so I want you to stay tuned.